With that, I will kick us off, Katie, with our hopefully these slides actually change. So yes, I suspect folks are largely familiar with our mission, but we do like to begin this presentation with our mission that we advance and enforce the legal rights, choices, and opportunities of Utahns with disabilities, and our vision, which I'm not going to usually read, but I guess I will today because we're actually recording. We'll share it with people. So the Disability Law Center envisions a just society where Utahns with disabilities are free from stigma, discrimination, and abuse. They have the authority to make their own decisions and the same rights and opportunities as those without disabilities. Their voices are heard, which inspires discussion and motivates change. Utahns with disabilities have equitable access to supports and resources needed to be as independent as possible and full participants in their communities. The reason we always kind of begin there is I think it is important to highlight kind of where we come from, because I think a lot of people wonder why we don't do guardianship, why we don't help people get guardianships, why we're not in that space. And the reality is it's because one, we um, we represent individuals, not parents. I think when we start representing parents, it presents a conflict for us because it's not something we can do. We represent the individuals themselves, and our vision for those folks is that they have the authority to make all the decisions they can. They have their voices are heard. They have self-determination and all those things. And guardianship really isn't that. And that's not to say guardianship is always wrong or bad, just that it's not something we're going to help people get, because again, it would really kind of go against our mission and our vision. And frankly, again, we can't represent parents in those scenarios because it would be a conflict with the individuals we do represent. So we like to begin there, I think, just as a high level, just so folks have that background and kind of understand a little bit more about why we don't represent parents in getting guardianships. Well, this is about our services, which I hope everyone on this call knows a little bit about. But for those out there in the world, this is a little bit of what the DLC does. Guardianship generally. Katie, do you want me to turn this over to you now, as we usually do, I believe?
Sure. Yes, that sounds great.
And I don't know if you can forward the slides, Katie. I don't know if you have the ability to do that. So if not, just let me know.
Okay. Oh yeah, I have a take control button.
Take control.
We'll find out what happens when I do so.
Ooh.
Did that work?
It did. I can take back whenever I'm ready. So
okay, excited. Perfect. Amazing. So so we have a number of things we're going to discuss about guardianship, but as Nate highlighted earlier, as an organization, we believe that individuals should have the ability to make as many choices as they're able to, with or without support and help for themselves about their own lives. And guardianship, we understand, is necessary in some situations, but we think it's really important to understand how it works, what it means, and when it might be appropriate and to what degree. So the definition of incapacity is an important definition in the statute. Ultimately, in order for a court to find that a limited or a full guardianship is necessary, they need to find that the person meets this definition of incapacity. So in a case, what would typically happen is a person, what's called a petitioner, often a parent, not always, but often a parent or family member, would file a petition to have guardianship over an individual. That individual is called the respondent. Sometimes we call them the protected person once guardianship is obtained over them. But that individual, the respondent, so the individual with a disability over whom guardianship is being sought, the court must find that they meet this definition of incapacity. So incapacity is ultimately measured by functional limitations and means a judicial determination after proof by clear and convincing evidence that an adult's ability to do the following is impaired to the extent that the individual lacks the ability, even with appropriate technological assistance. And we understand that to mean even with appropriate assistance. Technological could mean many things, right? To meet the essential requirements for financial protection or physical health, safety, or self-care, receive and evaluate information, make and communicate decisions, or provide for necessities such as food, shelter, clothing, healthcare, or safety. Obviously, that's a really broad range of needs, right? Oftentimes, when we talk about limited versus full guardianship, we might be like maybe someone does need help in a certain area, like finances, right? And so then how would their need be met? Are they actually incapacitated with regard to finance, or do they have the ability with appropriate technological assistance to meet the requirements, right? So those are some of the questions that are being asked. Are they incapacitated in those areas? Which areas are they incapacitated into? And do they actually meet the definition of incapacity? In order to use any of the alternatives that we're going to talk about, except for supported decision making, because that can look different. The individual must have the legal capacity to do so or to give consent in these areas. So in the realm of guardianship, right, as we said, sometimes we do understand that guardianship is necessary. We always think that the level of guardianship should be appropriate to the need of the person, right? And so if that's needing assistance in one or two areas, then that would be the most appropriate thing the court should find. If that's needing assistance in all areas, then that's what the court would find. But an individual should always, or respondent or protected person should always get to participate in those decisions. So these are two more sections of statute. The statute still calls the person the ward. We've trying to update some of that language to read protected person or respondent, because ward is that language, isn't sort of, I think, current in the way that we think about these things. But ultimately, a guardian should be encouraging the individual to participate in decisions, to exercise self-determination, to act on their own behalf to the degree that they can, to develop or to regain capacity so that they can manage their own affairs. A guardian should always consider the expressed desires and personal values of the individual. And then we'll get a little bit more into the Guardianship Bill of Rights, I think, but the Guardianship Bill of Rights is just that, a Bill of Rights that clarifies the rights that a person with a guardian has. There are some statutory restrictions now that sort of make it time limited, and you sort of have to do some math. And so we'll get into that a little bit later. But I'll just highlight that for you all on a high level. But ultimately, the Guardianship Bill of Rights really clarifies the rights that a person with a guardian retains. That's like the right to marry, the right to have privacy, the right to vote, like some of these other kinds of rights, right, that are not removed automatically under guardianship. And just because they're clarified in the Bill of Rights doesn't mean that they don't exist for someone if the Bill of Rights doesn't apply to them. I also want to be clear about that when we talk about math later with regard to the Bill of Rights. It's just that the Guardianship Bill of Rights clarifies them and makes them, outlines them, makes them clear. But we believe and understand that they exist in other areas of statute already. Let's see. Where are we? Do you want me to keep going, Nate, or do you want to hop back in at all?
You want to do this one and I'll take over the next couple then?
Yeah, that sounds good. So here we've got a few sort of truths about guardianship, right? So these are really areas that we see in statute, areas that we notice that people often have confusion about. So except as provided in a certain subsection of the code, part of the code we looked at already, a guardian has the same powers, rights, and duties respecting the ward that a parent has respecting the parent's unemancipated minor child. That's what the statute says, and that's what the statute affords. So ultimately what this means is that full guardianship legally takes away the protected persons or the individuals with the disabilities ability to make almost any choice for themselves. Oftentimes, even if a guardian or a parent is deciding to share decision making with their adult child who might be the protected person that they have guardianship over, legally that guardian has these powers. What we often see is, because the statute says this, right, and that is the legal authority that an individual has, we often will see then the same kind of protective behaviors that we might see from an actual parent to a minor child. We don't necessarily think that is the intention of the statute, right? This language in the statute is really outlining the legal, right, the legal powers that the person has. But oftentimes, especially when we have, I think, parents and children involved, parents and adult children involved, we sort of end up in that place that I think many of us can remember when we're sort of struggling with our parents with regard to, you know, personal choices that aren't necessarily making us unsafe, right? Dignity of risk, those kinds of things, because our parent might have some specific ideas about who we are, what we should be doing. That might be a little bit different than who we are. So that is what the law says and the law's intention. But sometimes we see that sort of play out in some other specific ways. So the next one here, decision making, of course, can be burdensome. It can be stressful. Few of us would want to give up the rights to make our own decisions. Not everyone might agree with my decisions. My parents might not always agree with my decisions. I know Nate's parents don't always agree with his decisions. But right, so but we sort of, as adults, right, we have a choice. We get to make choices, we get to make decisions as long as we're being safe. And so we think that it's really important to think about that when we're thinking about guardianship, right? What is it that a caller is looking for? What are they asking for? What are they talking about? What kinds of protections are they looking for? Is this about disagreeing with like behavior or choices of an individual with a disability, or is this about an individual with a disability not having the capacity to do certain things or needing assistance to do certain things, and sort of no other alternatives will work because they actually require some degree of protection for right safety. And so the bench book for the Utah State Courts, that's a sort of a book that judges have access to that gives them some guidance, really does outline this idea of really helping us to understand that a guardian really removes the rights of a person to make their own decisions. Next, guardianship doesn't have to be granted at 18. It often is. A lot of parents will petition for guardianship when their children are 17 and a half. That's when you can sort of start the process so that it goes into effect when you're 18. But oftentimes, a individual who's becoming an adult hasn't sort of gotten to test, right? Being an adult, making decisions, doing some of those things. And so a parent isn't required to obtain guardianship of their child who's becoming an adult at age 18 if they think that they might need help in certain areas, right? They can put lots of other protections in place, and Nate will talk about those shortly, those alternatives, to test and see if there are other options that will work, if the person can be supported in other ways, right? Guardianship can be sought at any age. And so parents don't necessarily sort of have to rush to begin the process at 18. And I think that that's one of the things that we often sort of hear maybe from teachers or from medical providers, right? This idea of, well, your child's turning 18 and you're going to need to be able to have permission to do some things or make decisions. And that's not necessarily, there are many other tools to use, right? Guardianship doesn't have to be the tool. And that leads us right into the next one, right? Guardianship is rarely needed to continue to play a role in the life of an adult with a disability. There are lots of other ways to do that, including just having that individual consent for you to continue to participate in the IEP process, for example, right? Or to attend medical visits or have access to medical records. Those are just a few of the ways, and Nate will touch more on those alternatives. And that's where we're at with the last one as well. There are other legal, medical, or financial tools that allow a parent or someone else to make decisions with or for an adult with a disability. I'm going to turn it over to Nate.
And that is the perfect segue into what are the alternatives and why are they important. So, as Katie kind of highlighted a little bit about guardianship, and what it really is, it's important to understand what some of the other options are, and then why people, really may want to utilize those and how they can be helpful. So we kind of have these in our list here on this slide in order of kind of most restrictive to least restrictive. So the first one is a limited guardianship, and Katie touched on that a little bit. That a plenary, a full guardianship is going to say that essentially a person has, somebody else makes all of the decisions except for the rights that may be retained in the Guardianship Bill of Rights or elsewhere in statute, like the right to marry or the right to vote. But a limited guardianship, which Utah law also prefers and says that ultimately that's what should be granted unless a full is absolutely necessary, would be just, picking an area of a person's life to have decision-making authority over. So, medical, financial, legal, whatever it may be. Some people just need assistance in certain areas. And so really the law should look for what those areas are and limit a guardianship to that if it is appropriate. And so that is kind of the most restrictive alternative to a full guardianship. It's still a guardianship, but it is kind of, less restrictive guardianship. Obviously, with the guardianship proceeding, even a limited guardianship, oftentimes you're always gonna have to go to court, but attorneys are gonna be involved most of the time, either for the parent, they're gonna assist a parent in getting that guardianship, and in our minds, always should be provided to the proposed protected person or proposed ward, as our statute would call them, but not always. But again, it's a court proceeding. It is a process that you have to follow. So it does require a little bit more to it. You have to meet the definition of incapacity, as Katie said. So again, all the alternatives below this are not always going to require an attorney or really any lengthy process. And so I think for a lot of parents, when they're looking at guardianship or alternatives, knowing that some of these things can afford you similar things without having to go through that process, that's also something to consider. And they are going to be easier to undo because, as Katie can tell you better than I, undoing a guardianship or having it terminated or transferred is a process as well. You have to go back to the court. You have to do that. Getting courts to essentially find that their initial finding of incapacity was wrong is a heavy lift. And so it just is hard to undo a guardianship, to terminate a guardianship. But it can often be transferred to another person or whatever. But again, it is harder to undo. Whereas something like a power of attorney, next on our list, really it does not require an attorney. Certainly you could have an attorney help you with a power of attorney. You could, go through that process if you wanted to. You could hire somebody to do that. It's going to be shorter and cheaper than guardianship, I would presume, because it's not going to require as much of an attorney's time. But again, it would give you decision-making authority for a person in a specific area. So it could be limited. It could be financial, healthcare, education. You could limit it to those things. You could make it more broad. But you can also make it springing or durable, meaning that it is either in place all the time when it is durable, or it is springing. It springs into effect when an occurrence happens. An example of this I know we have from somebody, not mine, but a colleague of ours, former client, was somebody who had, I believe, some kind of serious and persistent mental illness, and at times would go inpatient. And when they would go in an inpatient setting, their parents would get a springing power of attorney that they could help, pay their bills, make sure that their rent got paid and make sure, their finances were in order and healthcare decisions were made because they were in a setting where they needed assistance. But then after they were able to leave that setting and were stabilized, that would no longer be in effect. I don't know exactly. Maybe it was a month after, 2 months. I don't know exactly. It was, but the point is, it was something that went into effect for a period of time and then could stop, and didn't always have to be this thing where a person was, making decisions for you, but there was a time when you needed it. And that was something somebody did and did not have to rise to the level of a guardianship, but was able to have somebody make their decisions at an appropriate time. After that, there are other financial alternatives, right? One of the things I think people don't think about is I think if you're a parent and you want to stay involved in, your loved one's life when they become an adult, you can just have a joint account. So you can see the money they're spending and what they're doing. Maybe you can't control all of it, but you can at least have an idea about it. And so if a person is starting to, spend way more money than they should, you can see that and say, whoa, you need to, your rent needs to be paid. So don't spend more than this. You can kind of go over that with them and just having that. And there's obviously like more restrictive options like a conservatorship, which is just really a guardianship over financial. It's a little different, but that's basically it. So you can go through that process as well. You can also create a trust, which again is also going to require an attorney. I think another example would be an ABLE account. Could be something that might assist the person in the situation that wouldn't have to rise to the level of a trust, where with a trust, you're likely going to have to hire an estate planning attorney. And then obviously there's a rep payee. I think folks here are probably familiar, but a person with Social Security might just need somebody to assist them with their finances, and a rep payee a lot of times is really what a person needs. They don't need somebody to be a conservator or a guardian over their finances. They just need somebody to be able to help them manage their money and make sure they're doing it in a way that is appropriate. And a rep payee can often do that. There are other alternatives in healthcare settings, like an advance directive, which again, just telling medical professionals what you want, so somebody doesn't make that determination for you. Recently, I don't think this is actually in our slide about statutes, but I will note that we recently also did just amend our code to expand the use of mental health advance directives, which is an option people can use. I know it's something we're trying to develop some resources on the website about. Andrew should be working on that, so more to come soon, hopefully, on that one. But then obviously you can have a surrogate, somebody there who can assist, or living will. And honestly, I think these don't even get to the fact that you could truly, like, if you go into a doctor's office and the doctor's like, do you want this person here? You can just sign a HIPAA release, just to allow a person to be, contacted and do this. Medical professionals can do this. I think one of the difficult things we find in the medical community can be that oftentimes I think there is a concern about liability. And so I think they often want to see somebody make that decision because they fear there may be a litigious person out there who's going to be mad that a decision was made and shouldn't have been made. So I think it can get tricky in a medical setting, because I think sometimes doctors are think a guardianship is what is needed. But I think people, knowing your rights and knowing that that isn't what is needed, there are a lot of options to have alternatives. It is possible. And these are just some of the examples. I mean, as Katie said, I think this is true in an educational setting. You can just consent to having somebody be part of your IEP team meetings after you turn 18. Like it's really about consent and what the person wants. And I think oftentimes in certain settings, particularly education and medical settings, we often hear that they kind of steer people toward guardianship. But really, if the individual is over 18 and they want to consent to this person being a part of these processes, they can. And so some of it is just that simple. It's just giving that consent and allowing for that. With these last three, these really all get into a little more of allowing a person to have more decision-making authority than the others. So person-centered planning is a process that is used through the DSPD process. So when you're on the DSPD community support waiver, there is a person-centered planning process. And this is a process where you kind of get to make the decisions about what you want your services to look like. You have your support coordinator, you have whoever you want to be a part of that meeting. If you want your parent to be a part of it, they can. If you don't, they don't have to be. I think oftentimes people do, but if you don't, or if you want one of your parents and not the other, I think, it's really about kind of trying to plan around the services you want and make it as directed to what you would like as possible. And so I think for a lot of people, we see in the guardianship arena, people with intellectual and developmental disabilities, there is kind of this push towards needing a guardian. But if they're in DSPD services and they have this person-centered planning process, I think, all of that may not be necessary because they have the support around them. I mean, they should have a provider and staff and people providing all these things around them. And with this person-centered planning process, you can really be assured that they're getting what they want and what they need. And it's what they like. And so I think that is kind of the way I think about it as an alternative, is just that it kind of can really provide that wraparound help for a person in that setting. Now, if they're not on DSPD, that doesn't always work. Then there's shared decision-making, which is kind of an alternative to supportive decision-making, where somebody would kind of still retain most of their decision-making authority, but somebody else would have, also have decision-making authority on their behalf, where you kind of jointly make those decisions. We have not codified that in any way in Utah. It's not to say somebody couldn't use that, but I don't think it's something we see a lot of, but it is an option, I think, for people to know about as a thing. But then the one we have recently codified, which we'll talk more about later, is supportive decision-making, which we note here, but given that I have more slides on supportive decision-making, I'm going to move on to those slides now.
I was gonna hop in really quick and just say that.
Go.
So some of those things, like a power of attorney or a trust, obviously some of those things ideally especially if you want it to be sort of complicated, you would consult an attorney. But what I would say is that there are statutory forms. So there are forms that exist in statute or exist in code, that are sort of general forms, that an individual can actually access, as far as, decision-making authority, so financial, power of attorney, for medical power of attorney, those are also, in statute, or they're usually in kind of the packet. Every medical provider sort of has, a different packet. Some places call it like 5 wishes, some call it different things, but that's where you sort of do your, elections of your like healthcare agent, and it's sort of wrapped in with your advanced directive stuff. And so there are lots of forms that exist to sort of help you do some of these things. And so I think that if a person wants to do something that's sort of complicated or sort of novel, then I think an attorney is super important. But for a power of attorney, oftentimes you can use the statutory forms. Trusts look a little bit different. Trusts, you do need an attorney unless you use a pooled trust. And a pooled trust is an option as well. And that's highlighted in some of our fact sheets.
Excellent. So to support decision making is something we have obviously pushed a lot in trying to get a statute passed and some changes. And the reason for that, I hopefully is clear, in that it is one of the few alternatives to guardianship that allows decision making authority to remain with the individual. And so, even with the power of attorney, or other options, you're going to be giving away your right to make those decisions oftentimes, and it's still going to go to somebody else. It's not maybe as restrictive as a guardianship. It may not be as burdensome of a process, but ultimately you are still giving up your right to make those decisions. And supported decision making is really the concept is that a person would retain decision making authority with the appropriate support they need to make those decisions. I think the way we've kind of always thought about it is, again, it allows for this guidance and resources for a person to make the decisions for themselves, so they can communicate them themselves, but they just really have that support. It's kind of similar to person-centered planning, so I think it can be utilized in conjunction for somebody in the DSPD realm. I think it kind of they're very similar in that sense. It's really about allowing the person to make the decision with the support they need. It really is a way to increase self-determination. Studies have shown actually people who utilize supported decision making are more likely to report abuse, because I think, again, if you're more readily able to communicate, and you know these things about your rights and other things, and you kind of are involved in those discussions, I think you're more likely to recognize it and then also report it to somebody because it is bad. So it's not to say that people who have guardianships don't report, just that it has actually been shown to increase people reporting that. Obviously, it promotes people being able to advocate for themselves and maximizes their independence. So we are going to get into, I see a question already, but we're going to get into that. So don't you worry. That is some foreshadowing. That's a little bit about support decision making, but I think, obviously we have recently codified it. But I think the way I always think about supported decision making, I think we tried to highlight, is I don't think it is meaningfully different than how most of us make major decisions in our lives. I think, maybe it's the first time you buy a home, or the first time you buy a car, or you're a young person and it's the first credit card you get, or whatever it is. As you move forward in your life and you grow up, you have to start making your own decisions. And it is scary, as Katie noted in an earlier slide, it is stressful. But we all kind of look to the people around us. Hopefully we have people in our lives that can help us make those decisions. When I had to buy my house, I don't know the first thing about buying a house. Not a clue. Never did it before. It was just a thing I had to learn how to do. So what I do, I called people who knew who had done it before, my parents, and I talked to them about it and got advice, and they helped me make that decision. I still made the decision for myself, but I got the appropriate, advice. And so that may look different than for me and that it does for somebody else. Somebody else may need help making a decision about something not nearly as big as buying a house. But if they have the support around them and they can make that decision, then they should really be able to do so. And so, um, I think the other thing we'd like to highlight here, and I'm going to let Katie jump in with any thoughts she has on supported decision making before I jump to, I think the next we move into a little bit of the public policy stuff. So, but I just want to say one last thing, which is one of the other big things with supported decision making that I think we always need to highlight is the concept of dignity of risk. That there is dignity in being able to take risks. I think we all get to make choices in our lives and we get to make decisions, and sometimes they are bad decisions. As Katie rightfully pointed out, my parents did not always agree with my decisions. I think now they probably do, but certainly when I was younger, they definitely did not. But I got to make bad decisions. And I got to learn from those bad decisions. And I do think, for me personally, and again, I think ultimately like making bad decisions is one of the ways I've learned the most in life, because I did something probably stupid, and it didn't work out for me, and so I learned not to do that again, hopefully. But I think there is dignity in that. People get to make those decisions, and taking that away from somebody prohibits them from maybe learning from their mistakes. And again, I don't think that means you should let people make decisions that are going to be especially harmful, but that doesn't say it can't be a little bit harmful, right? Like, I like to, sometimes I probably didn't need that third donut. But it was delightful. And I got to make that decision. And it was not good for me. It was unhealthy. Probably isn't going to lead to a longer life. But also, it's not so dangerous that I shouldn't get to make that decision. That being said, there could be people for whom that could be a very dangerous decision. And so I think ultimately it's really about what the level of risk is and what is appropriate. But I do think we need to accept the idea that people get to make bad decisions and take risks within reason. And there is value in that. And I think it is harmful to not let people do that. I don't know, Katie, before we jump into some of the changes and a little bit more about kind of the law around that, do you want to touch on anything here?
Sure. Yes, all of that, Nate, everything you said. I think that when I think about supported decision making in sort of application, when I'm thinking about folks that either are currently under a guardianship and that guardianship is restrictive, or folks that an individual might be seeking guardianship against them, I think that when I think about it in that way, supported decision making can be a really effective tool that is an alternative to guardianship, right? Because you're sort of identifying the person or people in your life that you trust to talk about, certain decisions with. You talk to them about, what the decision is that you're trying to make, your thoughts about it, you get their thoughts about it, and then you ultimately still make the decision, right? But you have the input and support of these people that you've chosen and that have agreed to serve that role for you. And so I think that it can be a really great alternative to guardianship because, those people, if it's what the person wants, that person could be, their parent, person could be their sibling, person could be another trusted individual in their life, right? And so I think that it gives, and then I think that there's probably a degree if we're talking about a parent, for example, that has worries about their adult child or has concerns or whatever that looks like, but also, of course, wants to respect their ability to engage in the dignity of risk. I think that then gives that parent sort of a window into what it is their child is doing, and also helps them to be able to support their adult child. While at the same time letting that person retain their autonomy and their self-determination. So I think it's a really good balance and a really good option. And I've seen it be really effective for folks that I think might otherwise have ended up in a restrictive guardianship that one would have really restricted their rights, and two would have quite honestly destroyed their relationship with their family member. That's what I got, Nate.
No, that is helpful. And so with that, to the question about whether sport decision making is recognized as legal. What did happen this past legislative session in 2025 was that a bill passed, HB 334, which created and codified supported decision making as a recognized thing in Utah law. So yes, supported decision making is recognized under Utah law at this point. There are some guidelines, some guardrails in that statute. I believe we have that fact sheet on our website. If not, we will soon. But we are working on more materials around this for folks as a helpful thing. But ultimately, it really just has to be something a person consents to. That if a person wishes to enter into this, they're a person with a disability, and they want to do this, they have to have at least one supporter. You can have multiple, but you have to have at least one. It cannot be coerced. It can't be, the person can't be pressured into doing this in any way. It has to be something they want to do. They can terminate it at any time. A supporter can also opt to leave at any time, which I know some people are like, well, that, then what if somebody's and if every supporter leaves, then again, there's no agreement in effect, and they would have to kind of work through that, unless a successor is designated, which a person could do in the agreement. We tried not to, in statute, specify too much about what all the requirements are. I think we tried to offer protections. People can't use this to financially exploit someone. Like, there are aspects of this which would offer protections, but ultimately we tried not to be too prescriptive about what an agreement has to look like, because it is really supposed to be tailored to what the person wants. It could be a person with a limited guardianship for financial reasons, but then wants to utilize supported decision making for healthcare reasons, and or other decisions. And so it really can be tailored to the needs of the individual, and it hasn't really been overly prescriptive about what it has to look like exactly. Trying to think if there's any other, are there any other things we want to highlight from the statute, Katie, that you can think of? I mean, I think.
Yeah, I was just going to say, one thing I would say is a person who is under guardianship, so say like a person has a limited guardianship, or plenary guardianship, right? And that person wants to engage in supported decision making. There is a way for them to do that. If the area where they want to engage in supported decision making is covered by the guardianship, then the guardian would have to consent. I believe is how we ended up in the statute, right, Nate? So the guardian would have to consent or sort of approve that supported decision making plan, because that was a concern, I think. There was some maybe misunderstanding, or sort of when we're demystifying ideas, sort of those are questions that come up. And so the idea is that if someone has a guardian, does that guardian is supported decision making in any way diminishing or changing that guardian's rights without the guardian's consent? And the answer is no. I would say that's important, I think.
Yes, and I guess I should, the what is called a principal, the person who enters into the agreement, has to be 18 years or older, obviously. So they have to be somebody who can consent to this. And the supporter also has to be 18 or older. And they also can't be paid to provide support to the individual unless it's through caregiver compensation or a sibling who cares for them. We went back and forth on this in negotiations. I'll be honest, I don't know that I agree with where we came down, but this is what is right now. You can't have a paid supporter under a supported decision-making agreement, except for some very limited circumstances. They also can't have a substantiated allegation of abuse, neglect, or exploitation, a protective order, or a conviction of harm of another, theft, or a financial crime. And they must agree to be able to provide the support the individual needs. So there are, again, just some of those protections to try and avoid any problems with supported decision making. But yes, Katie's absolutely right that if the person has a guardian, it essentially has to go through a process to make sure that a person isn't utilizing this and has the capacity to do so. That was some of the concern we had from guardians. But the agreement does need to be in writing. It needs to have an effective date, designate at least one supporter, and describe how the support will be provided, and signed by the principal, a supporter, a guardian conservator if required, and 2 witnesses or a notary public. And if there are any conflicts of interest, it needs to be discussed how they will be mitigated. Those are some of the actual protections I should note as well. So, and again, if there is like an overriding document, like a power of attorney or something, that would also obviously terminate the agreement if that was created at a later date. Look, you have something to add, Katie.
Oh, Evelyn just asked a question in the chat. So yes and no is going to be my answer. So the question was, if I'll just read the question. If a guardian agreed to change from guardianship to supported decision making, does the guardianship have to be removed in court? So there's a couple different ways this can work, right?
Yeah.
So supported decision making and guardianship can be used in tandem. If a person already has a guardian and they have, usually it makes more sense if they have a limited guardian, right? So if they have a guardian in certain areas and they want to use supported decision making in certain areas, that's probably the most typical way that the two things would be used together. But it is possible for an individual to want to use supported decision making in some areas where the guardianship is working, and that's when a guardian would be involved, need to consent, need to do all of the things to figure out like how do the two things work together. So that's one way that that could happen. The other way that that could happen is if a guardian evaluates supported decision making, talks about it with the individual over whom they have guardianship, and they determine that supported decision making would be a better option or a workable option, and perhaps the guardianship isn't necessary because these other tools exist, then yes, the guardian or the protected person or both, ideally both, if they are in agreement, they would both go to the court. They would petition the court to terminate the guardianship or to modify the guardianship to make it more limited. So then supported decision making could cover, right, the areas where they think that's appropriate. So yes, if the guardianship itself was going to be modified in any way by supported decision making, like actually change the mechanism of the guardianship, yes, that is the thing you would go to court and you would ask for a modification or a termination. However, if you're just using the two things in tandem or you're using them sort of in partnership, then no, that wouldn't need to be changed in court. I hope that answers the question.
Yeah, and I mean, I think honestly, I would, and I'm going to try and go back to the right slide here if I can find it. But I would actually argue that yes, one of the things we cite to earlier in the presentation about guardianship, that that a guardian shall, to the extent practical, encourage the ward to participate in decisions, exercise self-determination, act on the ward's own behalf, and develop an agreeing capacity to maintain their personal affairs. I think, actually, to me, signals that supported decision making is a, whether the agreement needs to be formed when somebody has a guardian, the principles of it should exist within a guardianship. I don't think that is always the case, but I think the concept in our state statute is that is really what you're supposed to be after, is trying to use that concept when making working with your protected person. So but Katie answered it brilliantly with respect to like how the legalities of it would work. But ultimately, I do think it's something that should be a kind of something that should be utilized while you have a guardianship. And I think, frankly, if you had a guardianship and you felt like it wasn't maybe necessary, I think one thing you could do is try support decision making, form the agreement, use it, and see if it works. And if it starts really working, you're like, well, this really works well, and maybe I don't need this. You could go back to the court and say, this isn't what we need. And I would hope, I think most courts would agree at that point, if you could show that you had tried this process and it was working, they'd probably be more likely to be like, yes, we've seen this alternative work, and like we're gonna, maybe make it a limited guardianship, or we're gonna terminate the guardianship, or a temporary, pause in the guardianship for 6 months while we see how it works. I mean, there's a lot of things the court could do, but ultimately, the short of this all really is that supported decision making is codified in law as a process people can use. They can form these agreements. We have some information on our website. I know it's something that if people have more questions about, I know Katie and I would probably at a minimum be willing to talk to anyone who has questions about utilizing this process or doing that. Real quickly, because I know we're coming up at least short on time, though I can keep going if folks are okay, as long as nobody has any conflicts. But I do want to note the Guardianship Bill of Rights that Katie mentioned earlier. We have updated our fact sheet on our website to reflect what the changes in law are now. But essentially, there was, I think, some confusion about the whole thing and concern that people had. And so it was modified in the same bill, HB 334, to really clarify what rights are waivable and what are not. So courts, before, it wasn't clear if a court could waive certain rights or not. Now it is clear that for any guardianship, full guardianship that is granted after May 7th of 2025, then you would have, these rights would have to either, there are certain rights that are non-waivable by the court and certain rights that could be waived if a court decides that they are things they want to waive for your guardianship, and they would have to specify that. If your guardianship was granted prior to May 7th of 2025, then whatever was the law at the time is what would apply. And so, again, Katie and I might disagree with what some people think about what rights people had when they had a guardianship prior to that date. But ultimately, that's what's going to be in effect, and it's that question of when it is. There is, like Katie said, there is some math there involved, I guess. It's a little bit more complicated than that, but that is a simplified version of when the Bill of Rights apply. And so, but again, all of that information is clear on our website. We did update the fact sheet. I just did it like a couple of days ago, actually. So it's actually up to date and correct. Lastly, I think we need to note that we've mentioned this before, but this year also there was another bill passed called SB 199 that created a special guardianship. We have argued in pleadings that it is an ultra guardianship for those with a severe intellectual disability. I probably won't get too in depth on this because we did challenge this law under the ADA, among other things, in federal courts. Our case was dismissed at the time based on non-merit based arguments, just that a lot of legal stuff. But right now, I think we're trying to figure out our next steps. So I'm probably not getting too in depth about what we think about it, other than to say it creates a guardianship for those with severe intellectual disabilities. When a physician or psychologist has said an intellectual disability is severe, you can essentially qualify for this guardianship, which limits when you would be provided an attorney, your rights to challenge that guardianship, your right to associate, and your right to make even more decisions about your life. So it is. We view it as overly restrictive and unnecessary, because I think if a person wanted to create a similar guardianship to what is proposed in this law, they would just have to actually go through an individualized process with the court to make a determination if those rights should be removed. And right now, it just kind of blanket takes those rights away. And so frankly, we're not proponents of this, but more to come on that later as we learn more and we figure out what exactly the law is around this. But certainly, if folks have questions, they are free to reach out to probably me, unfortunately. So that is a little bit about the changes that we've seen to guardianship in the law. Here's just a bunch of links. I will make sure that everyone on this actually gets this so they can click on those links. And I will make sure that this actually gets put on our website so that people who are seeing this later can find these links as well, to all these resources, so people have them. Just a bunch of different stuff that we've tried to highlight over the years of like what might be helpful to folks in the guardianship space. And with that, I think we're open to questions. We only have technically 2 minutes left in our meeting, but I know I can hang out for longer if Katie
I
can
as well. Yes.
So I see somebody is typing in the chat, so I'm gonna let that typing happen. But if anyone really wants their voice to be heard, they're also welcome to unmute and ask any question they would like. Or you can type it in the chat if you prefer not to have your voice be heard. What's the process to determine incapacity? Is there a list of requirements to present to the court? That sounds like a question for Katie.
Well, that's a great question. So theoretically, yes. I think it sort of depends, unfortunately, judge by judge, sort of what that process looks like. But yes, the statute sort of outlines, what incapacity is, what it means, and the ways in which you might sort of prove that. I would also say that we've been working on updating the court's forms. So if someone has an attorney, usually the attorney is going to be using their own forms and doing their own thing. But if a person is proceeding pro se, then they would be using the court's forms. And the court's forms are, we're trying to make them really clear, so that they show, so I work on a subcommittee that does that, a group, drafting group, that to really be clear about, yes, like, why is it that you need a guardianship? Why do you believe the person is incapacity? What documentation do you have? And so when we're talking about incapacity, what the court is really looking for and what a person should be thinking about when they're thinking about incapacity is documentation from a medical provider about what it is that a person can or cannot do. And specifically, we're talking there about not just we're not just talking about like an intellectual capacity. Like I want to be clear that we're not talking about IQ. We're not talking about any of that. We're talking about functional limitations, right? We're talking about those things taken together. If a person can or cannot sort of engage in the things that a person needs to engage in, make the decisions a person needs to make with or without help, in order to be safe in all of the ways we talked about earlier, right? And so, um, and so appropriate documentation that a court would want to see would be from a healthcare provider, from a psychologist or a psychiatrist, maybe, right? Like from folks, from professionals in that person's life that show what a person might need assistance with. And those things are usually pretty detailed. Ideally, right? We might be looking at a psychological evaluation, or we might be looking at detailed documentation from a provider, those kinds of things. What a court usually, the thing you would want to put in a court isn't just like a one-page filled in form, right? That's not an ideal situation. You want, if a person is sort of looking to establish that the person they're seeking guardianship for is incapacitated, you're going to want to show your work, right? Show that documentation, provide the appropriate evidence, right? To show like why guardianship and why whatever level of guardianship the person is seeking is appropriate, particularly because the state does prefer a limited guardianship. And so I would say there's not necessarily like a list, a checkbox list, but it's really about show the documentation, show why guardianship and whatever level of guardianship you're looking for is appropriate. Why one of the questions that's asked is, what alternatives have you tried and why aren't they enough? Right. So a lot of those things are the kinds of questions you're looking at. What is it that the person requires assistance with? Why aren't alternatives working? What have you tried? And then what documentation do you have to show that you believe that this person should be found to be incapacitated in these areas? Nate, I don't know if there's anything you want to add.
No, just that I think, the one that Katie mentioned last, the what alternatives have been tried and why aren't they successful, is
Yep.
probably the question I find most frustrating, that I don't think courts ask often enough
Yep.
In guardianship proceedings, because I think that is probably one of the most important questions. And so, does the court want to hear from the individual though? Do they interview them? Oof.
Yeah, so good question. So again, I'm going to say it depends on the judge. So what typically happens in a case is, and it depends on the district that the case is brought in, right? So in Salt Lake, we're in the 3rd district. And so there are different districts throughout the state, right? And every district handles their so guardianship cases are considered part of probate. That's like the part of the court that they're in. So different districts handle their probate docket differently. So for example, in the 3rd district, the way that we handle the probate docket is cases, guardianship, so petitions for guardianship come through and they get added to what we sort of colloquially call a cattle call, but ultimately it's sort of where there's a whole bunch of stuff on a docket and it's sort of like your initial appearance in front of a judge, right? And then and that judge isn't necessarily the judge that's assigned to your case, but it's just sort of like a first look at situations, right? And so there's usually one judge assigned at any given time, in the 3rd district at least. And some other districts do it this way, or they might have one specific judge that handles the guardianship cases in the probate docket on like every other Tuesday or something like that, right? So every district's a little bit different. But in that sort of initial appearance, those are sort of quick appearances in front of whoever the judge is that's handling those cases. Usually that judge is going to ask just a few questions like, what they're checking for is to make sure that all of the things that are supposed to be in the file are in the file. Have all of the testing things been submitted? Is the documentation there? All of that. Does the person have an attorney? Do they need an attorney? Because a respondent, a person with a disability, right? A person over whom guardianship is being sought, that person has a right to an attorney. And so if they don't already have an attorney, then that judge is gonna say like, okay, well then they need an attorney because the criteria there's a very limited waiver, and there's like 7 things that have to be true in order for you to not have an attorney. And so if they're going to say, does the person meet that criteria? Do they not meet that criteria? If they don't already have an attorney, we're going to try to get them an attorney. If one isn't available, they'll either look around the courtroom and be like, you there, I would like you to serve as this person's attorney. That happens sometimes. Sometimes they're going to send them to what's called the Guardianship Signature Program, which is a group of volunteer attorneys around the state that represent folks. And I occasionally, do that for folks that don't have an attorney otherwise. And so sort of that initial appearance is the file complete? Does the person need an attorney? Sort of what's going on? And yes, usually at that appearance, depending on what's going on and who the judge is, they're probably going to ask folks seeking guardianship, the petitioners, like what's going on, and then they're going to ask the alleged incapacitated person or the person with a disability, the person over whom guardianship is being sought. They're going to ask them sort of what they think, how they feel. Do they oppose it? Do they agree with it? Do they think they need help? Some of those things are going to happen. I think that sometimes what we see there is, depending on who that judge is, the difficulty there is they might say to that person, well, do you need help? Do you want your parents to help you with those things? And that person says, well, yeah, I'd like some help. And they say, great. It sounds like you are consenting to guardianship and we shall grant one. I don't think that's actually what's happening in those situations. And I think that judges are thinking more sort of closely about those issues and if that's actually what should be happening, right? Because this is just an initial appearance when we're having an initial conversation, making sure sort of everything is in place. Some guardianships are granted at that time. And we as the DLC do think that's, problematic potentially. And because it should be really more of a vetted process, there should be more of a, just because someone says they need help doesn't mean that they're consenting to sort of have their rights taken away or that they're consenting to being incapacitated, right? And so what should be happening is after that initial appearance, and then after the person has an attorney, and after all the things are in place, all the interested parties are served with the notice of petition, there's an opportunity to object, right? So if the person that over whom the guardianship is being sought objects, then they have an opportunity to object and say why in writing or in verbally. Other people in their life, right? If those are other family members, other interested parties would also have an opportunity to object. Then it would go to the assigned judge, and then that judge would have a hearing, would determine, okay, where are we at? Who do I need to hear from? Who do I need to talk to? Do we need to have more of like a trial kind of a situation to determine what this is going to look like, et cetera? And so, and that's sort of what would happen later if changes want to be made to a guardianship or a termination needs to occur. So I would say it's relatively typical at that initial appearance that a question or two might be asked to the individual. It is more typical that more questions would be asked when they're in front of the assigned judge, right? Yes, they would be asked about the things that they can do, the things they need help with, what they think about the person that's their proposed guardian. Do they want a guardian? Do they think they need a guardian? What's going on in their life, right? The other thing I would think would be, the other thing that's important to state is sometimes a court will appoint what's called a court visitor. Sometimes that can happen at the beginning. That might be if an attorney just isn't available, they'll automatically assign a court visitor. If the person just can't have an attorney, we want somebody to have eyes on this person, right? We want there to be due process. We want there to be protections. And so the court can assign what's called a court visitor from the court visitor program. And that's an individual from a court program that goes out, that meets with the person, talks to them about what's going on, evaluates sort of their life, their living situation, their needs, all of that. Also is going to talk potentially to proposed guardian, to other important people in their lives, maybe their medical providers, right? And that court visitor is going to bring back to the judge information. A court visitor is someone who's also used later on in the guardianship process when we're looking maybe to modify or terminate, or when there's a conflict between the guardian and the protected person that isn't being resolved and that the court doesn't have a good picture of what's happening when we're maybe alleging the guardianship's restrictive or something. A court visitor is a tool that can get in there and sort of serves as the court's eyes and ears in the person's life. I know that was a very long answer, but I hope it made sense.
I think it made sense. Sounds like others do too. I know we've already gone over, but I mean, this is to be helpful to others. So if you have any more questions, please let us know. And if nothing comes to mind now, if you just want to think on this, because it was a lot of information just thrown at you over the last hour plus, we're more than happy to talk later. And that is true for anyone listening later. If you have questions, you can send us questions. We're happy to answer them later. But that is, yeah, if there are no more questions, I will just say thank you all.